we'll sit down for a Q&A. For people online, if you have questions, please submit those through the Q&A feature in the chat. And so with no further ado, last year I said a lot of stuff. Was it embarrassing stuff I said about you last year, Bob? I don't remember. I'll do a little story. Every once in a while, I'm talking with my colleagues about something. They're like, oh, there's this new thing out, blah, 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 blah. And always can be like, oh, Bob has a podcast. Bob talked with him on that. Bob is a cornerstone of legal tech who has been documenting legal tech since before we were probably calling it legal tech. So take it away, Bob.
Since before most of you were born, I think, unfortunately. Been doing it a while. Well, thanks, David and everybody at Suffolk for doing this panel. I'm really looking forward to the conversation today. I want to give a special shout out to Sam Glover over there, who did a lot of the legwork in pulling together this panel. So thanks, Sam. I think, in the legal world, one of the great promises of technology is always the potential to help bridge the justice gap, to make legal help more accessible to those who are not able to access it because of cost or geography or language or whatever other barrier may stand in their way. And yet one of the ironies, I think, of the legal technology world, at least the world as I cover it, is that so much of the development that's happening in legal tech, so much of the innovation that's happening in legal tech is not focused on those who are having difficulty accessing the system. It's focusing on those who have excessive access to the system. It's focused on the rich. It's focused on big law firms. It's focused on corporate legal. So today, I think what we're going to do is we're going to hear from 4 people who are kind of flipping that balance, who are pushing innovation in access to justice in poverty law. And as Sam said, what we're going to do is the format will be, we are going to spend about 10 minutes with each speaker getting up and telling you a little bit about what they're doing and showing you a little bit about what they're doing. And then we will have a Q&A discussion. I've got some questions I want to ask them all, but we're also going to welcome you in the audience to ask questions as well. David, I don't know how to access questions in the chat, so you'll have to tell me if there are questions that come in that way. Rather than go through and introduce everybody up front, as they're getting up, I'm going to introduce them one by one as they get up and let them tell you more about who they are and what they do. So without further ado, Jessica Frank is going to kick it off. Jessica?
I can't kick anything because I have a sprained ankle, but
I didn't know you were crippled, Jessica.
I'm really committed to access to justice. Okay, so let me move my presentation over. Okay. All right, good, it worked. So I am Jessica Frank. I'm the Director of Justice Initiatives at Free Law Project. And I'm going to start a little bit on the free law side and then talk about how that moves into the access to justice side. So Free Law Project is a nonprofit with a simple premise that the legal system runs on public data, and that data should actually be public. And so courts are publicly funded institutions. The information they produce belongs to everyone. And Free Law Project has spent 15 years building the infrastructure to make that real. Our tools include Court Listener, which is a database and research platform with 10 million and counting opinions across all 50 states and the federal court system. We have the Recap Archive, which is the largest database of federal docket information and filings outside of PACER, with 500 million docket entries across 57 million cases. And we have the Recap Extension, which is a browser extension used by 35,000 people to pull content in and publicly create this public corpus of data to crowdsource access to this information. We also have an oral arguments database, which has about 3.2 million minutes of Oral arguments across the federal system. If you do practice in the federal appellate system, it is kind of cool to go search yourself. I've done that in demos, and lawyers really like to hear themselves. Or if you work for an attorney who's in the appellate side. They're all searchable as well. And so for student purposes, if you are in moot court and you are practicing and preparing for an oral argument, go search for your topic and listen to how real lawyers and real judges are talking about that in the federal court system. If you're really deep in the nerds weeds, you can create a podcast where you can download and listen to oral arguments while you run. I haven't moved that far, but you do you. We have a judges database, which pulls in financial disclosures and judicial information for judges across the country. It was used by the Wall Street Journal a few years ago to find that 100 plus judges had conflicts of interest in cases that they were hearing. And we put all of that data, all that structured legal data, and open it up for lawyers, for researchers, for journalists, and for commercial products to build on top of it. So this is foundational infrastructure for our judicial system, and it's the basis of what I'm going to talk about in the tools we're building in the justice initiatives. So the statistics, we know about them for the access to justice gap and the civil justice crisis in America. The numbers get cited a lot, but I want to dig into them a little bit. The representation gap that we hear about, the numbers that come out of the Legal Services Corporation and other news articles, don't just stop at legal aid eligibility. There is a huge population of people who don't qualify for legal aid and who still cannot afford an attorney. They're just on their own. They're the self-represented litigant population. And in the majority of civil courts today, in courtrooms, self-represented litigants are the majority of the customer. They are the main customer base in a system that was designed for lawyers. And this isn't just an edge case anymore. This is the baseline. This is who is interacting with our judicial system at any given point. That's where my work comes in. So I have spent about 15 years in this space. I am an attorney, but I've never really practiced in court. I managed a document assembly tool, another open source project before this, and I moved to Free Law Project about a year and a half ago to pull together the data and the infrastructure that Free Law has and put it to use for the people who need it the most. So that's what our Justice Initiatives division does. We are building tools for real self-represented litigants, not demos, not proof of concepts. We want to make sure that the SRLs who are relying on them at 3 in the morning, that the tool doesn't fail them when they're the most vulnerable. The 2 main projects that I'm going to talk to you about are our litigant portal, which is an AWS supported under an Imagine grant, and our work with the federal defenders, because both come from the premise that the real tools have to help at the crunch point, and they have to ensure that the system works all the way through. So the litigant portal is a Gen AI powered tool designed to help self-represented litigants understand their legal situation, prepare their court-ready documents, navigate procedural requirements without an attorney, and prepare them for the interaction that they're about to have with the judicial system, including then reminders as they move through the process and additional help as they go along. So there are a few things that I think make the litigant portal stand out. First, it is grounded. Every legal statement that the system makes comes from a verifiable source. Free Law Project has a unique corpus of legal data that many of the foundational models rely on. Thousands of commercial products are using our data, journalists, academics. And so we're going to use our own data. We're going to eat our own dog food here and make sure that every output that our system generates is based in this knowledge base. This is a schematic that we had as part of our Amazon grant, but it shows the workflow of a user interacting with the system, how it's going to run through, and how it's basing it on our knowledge base, which includes the content that's from Free Law, but also heuristics and jurisdictional specific materials, forms that have already been created, all of the form automation and self-help that has already been created in the space for the past 30, 40 years. We want to build on top of that to produce the content that is jurisdiction specific for our litigants. The SRLs are already out there searching in ChatGPT or Claude One of the examples I give, I'm in a local moms group on Facebook in my area in Northwest Florida, and regularly people ask questions like, hey, has anyone ever dealt with XYZ legal situation? And there is always an answer that says, hey, I heard ChatGPT could do that for you. You should just try that. And I'm always like, oh my God, please use Florida DIY. At least it's coming from a legitimate source. But also, I'm not your lawyer, so I don't want follow-up questions. But I'm really trying to balance that thing. But people are using it, and so we have to provide the tools to recognize that the majority of the people in the courtroom are there without lawyers. They're held to the same procedural standards as attorneys, and they're going to use the tools that are publicly available to them. Let's connect all those dots so that they have tools that work for them. The problem with like the ChatGPT or going to Claude is that SRLs don't have that gut instinct that lawyers have. I have been doing this for 15 years, and as an attorney, you all know your neighbor will be like, hey, I have this legal issue. Can you help me with this type of law? Or your cousin will be like, hey, I have a dispute with my landlord. What do I do? And I'm like, I don't know. I don't practice in Wisconsin in tenant law. Like, well, I don't know. Here's a reliable source, though. And so we have that gut instinct as attorneys that teach us when something feels legitimate or when it is a legitimate research option. And SRLs don't have that gut instinct. And so the AI tools are meant to gaslight you. They're meant to sound authoritative, and they sound really great. And the answer the SRL gets sounds great, but it might not work for their jurisdiction. And so we need to have the tools that are jurisdiction specific and actually provide the correct legal information. The part here with the court is that we want this litigant portal to come through a court partnership. So if you think about what it's like to actually be a self-represented litigant trying to find help, you search your situation online, you get attorney ads, you get LegalZoom, you get that AI chatbot that pops up in Google that's going to confidently tell you things that might not be accurate. Maybe you're going to find a legal aid site if you're lucky. There's no signal for what's trustworthy, and that gut instinct that I talked about, SRLs don't have that. But if the tool lives on the court's website, it gives a legitimacy and a signal that this is part of the institution in a way that the SEO search results are never going to give us in this access to justice space. And so the litigant doesn't have to evaluate whether this is a good tool or not. It is coming from the court, and so they have already made that determination. And so that's why the litigant portal is a partnership with the courts. We are asking courts to work with us to build the tools that work for them and for the self-represented litigant population, and to pilot it and test it with real self-represented litigants. I'm sure you all have seen the Morgan versus V2X case out of Colorado that talked about a pro se using a ChatGPT or Claude. It wasn't clear what the tool was, but that it didn't have the same sort of security and privacy that was needed in use in discovery. And the judge noted in a footnote that what's going to happen when large law firms have access to this enterprise grade software, but self-represented litigants don't. That's where our litigant portal hopefully sits. We're going to provide that enterprise level jurisdiction specific materials that the self-represented litigants can use. I also want to briefly flag our work in the federal defender space because the representation gap doesn't end with civil court. On the criminal defense side, the failure of the system looks a little bit different. So there is a lawyer, but that lawyer may be carrying a caseload of several cases and have a volume of evidence that's coming through from the government that doesn't make preparation, it's nearly impossible to keep up with it. So they used to get several boxes of discovery. Then the equivalent now is that a semi-truck is backing up to their office and dumping out all of that information. And how do you handle 8 terabytes of information when you have a hearing in 2 weeks and someone's life is on the line? And the government has tools that it can use to process that, flag it, create this narrative, but the defender side doesn't have those tools. So we're working with a federal public defender's office to help them think through how do they handle this volume of discovery from body cam footage, from drones, from street cameras, from whatever 5 years of investigation and all of the multimedia methods that they have. How do they handle that and actually provide representation that is constitutionally required? So we are in the early designs of scoping with them, and we're talking about how to get their hands around this semi truck now that backs up to every single case that their office gets. I'll close with my direct ask here, in case I don't get to it. So we're looking for court partners for our litigant portal. We want courts from the tiniest little one judge who wants to do this and do something innovative about the self-represented litigants who keep showing up, to, like, I'm not going to turn you away if you were the state of California and you wanted to do this across the whole state. But really, we want people who are actively engaged in this room, and hearing about the student projects and how your students have worked with the Massachusetts courts is really inspiring. Okay. I want that kind of relationship. I want to be in there talking about how this works for the clerks, because I want their buy-in. I want to know how this works for the judges, that they're actually getting completed forms all the way through, and that people are showing up prepared for court, because that's going to make the system better for everyone who is participating in it. If you are a researcher, a technologist, or a legal aid who wants to build on top of our open infrastructure, we are open source. Everything we do is also on GitHub. And our APIs are available for law students to build with at the commercial level. So get your .edu memberships, and they include our full commercial API access. So yeah, my contact info is on the screen. If you want to talk after, I'll be around. So thank you.
Jessica, thanks so much. Our next speaker is Sonja Ebron, the CEO of Courtroom 5, and somebody I just wrote about last week for the really cool stuff she's building. So she's going to show you a little bit about that.
Good morning. Let me first say thanks to Bob for covering our Law Accelerator last week on the Law Sites blog. I think that is probably, I would probably refer you to that for the best description. He went way over the top, very kind in describing what we do. But I'll give you just a quick overview of it. I want to hear what my other colleagues have, and it took me well over half an hour to walk Bob through our app. So I won't take our time to do that today. I'll just give you a sense of what we do. Before I do that, though, I think really it's more important to talk about why we do it. So we run the Law Accelerator at Courtroom 5. It is a structured program to sort of compress the time to competence in litigation for people in court without a lawyer, pro se litigants, as we all call them. I am probably amongst very few of us in the room without a license to practice law. And I think that maybe gives me a novel perspective on the access to justice crisis, just a different perspective than many of you have. I am trained as an electrical engineer. And specifically, I studied the quality and reliability of our electric power grid. So power plants, transformers, right? The lines that bring power to our homes and businesses. And I've been thinking about that a lot lately because I see some parallels to where our electric grid was 70 years ago, thereabouts, and what our justice system looks like today. Let me just take a couple minutes and show you those parallels. So it's maybe hard to believe, but before the Civil Rights Movement, the power lines would actually stop on the outskirts of poor and ethnic minority neighborhoods, right? You just couldn't get power. So if you lived in one of those neighborhoods, you were burning oil lamps for lighting, you were burning kerosene heaters for heat. But you could look like right across the street or right across the railroad tracks, and you could see power lines going to houses with electric lighting, all kinds of fancy kitchen equipment, and that sort of thing. But you couldn't get them in your neighborhoods for a number of reasons. After the Civil Rights Movement, we corrected a lot of that. It took a few decades, but what happened was, and it was litigation, it was public utility boards that forced utility companies to provide universal access to electricity, right? Before that happened, lights would flicker all the time. They didn't last long. Toaster ovens would just blow up randomly, right? If you looked at a power line on the street too long, it would just drop on the ground. I mean, it's just horrible. Right? It was a really horrible system. And you can understand because we had these deserts of no electricity and then a lot of, places with electricity. And it was just a crappy electric grid because of that. So once we had universal access, what we saw over the next decades was dramatic increases in the quality of power in that system. And in the reliability of it. We don't get too many outages these days. You got to have a winter storm or something like that for a substantial outage. Our light bulbs, let me look at all of this, right? The quality of the power coming into our homes and businesses is a lot better as a result. And so I think maybe there's a correlation between universal access and the way the system performs for everybody. My co-founder, let me find the camera here, the beautiful and brilliant Dr. Deborah Sloan spent 20 years as a public librarian and library school professor. And she would tell you a similar story about public libraries. So before the Civil Rights Movement, very few people had access to public libraries. A lot of us did not. And yet, after the Civil Rights Movement, when we had universal access, we saw the breadth of library services, the quality of our libraries dramatically improve, right? And so again, maybe there's a relationship between universal access and the quality and reliability of the system and the services the system delivers. I think the same may be true in our justice system. That's the parallel that I want to draw here, right? It is possible, and I believe that if we have universal access to justice, that the justice system will work better for everybody. All of the services that are delivered will be better for everybody. Let me give you a quick example. We all know, you all know that most cases don't proceed to trial. And trial is the best outcome possible in the justice system because we get a decision on the merits. But what we typically get is some kind of settlement for a whole bunch of other reasons, or folks lose on procedural grounds, right? That's a crappy justice system. We're missing a lot of data from people who could, maybe have meritorious claims or maybe don't, but we don't get decisions on the merits. And that means we have a lot of risk in going to trial. Nobody wants to put a case in front of a jury. You don't know what you're going to get. I think that's because of the lack of data. That's because so many people don't get their fact patterns and their claims put before those juries. And so, again, I think if we can do universal access to justice, we can have a much better system for all of us. That's the why for Courtroom 5, and that's why we've built the Law Accelerator. Essentially, we want to put litigation competence in the hands of everybody. The numbers won't work for getting everybody a lawyer. That's just never going to happen. Even with AI and improved efficiency and all of that, everybody's not going to be represented. And so what we need is for individuals to be able to go into court and get meaningful access to justice on their own. Let's see here. Can I use a mouse? There we go. All right, let me just walk you through briefly what we do. And again, I won't spend time on a demo. Check out Bob's article. There's, I think at the top of our page, you'll see something like features, and you can watch some of the things there. But again, our goal is in very, very procedurally complex cases like these, right? High conflict child custody and visitation or divorce, legal malpractice, we get quite a bit of those, home foreclosures. These are cases that may take years to get, from a complaint to a trial or an appeal. We want to make sure that self-represented litigants can carry that load. And very often in these cases, they are up against a lawyer, a party that is represented on the other side. And so our goal is to maximize their competence at litigation in a very short period of time. Law Accelerator, law there actually is an acronym that stands for Learn How Courts Really Work. Many folks come to this process thinking Judge Judy, and I just got to tell my story. The kindly judge will make a great decision. Doesn't work that way, as you all know. A stands for Acting with Safe AI Legal Tools. And then W stands for Walking in Community with others on the same fight for justice. So, how does it work? There are four key components of our accelerator. The proof component helps our users connect the facts to evidence, but more importantly, to the claims and defenses in their cases and the elements defined in the law thereof, of those claims. And so you all know, most pro se litigants, they know that what happened to them. Sometimes they'll have evidence that might support claims and defenses. Occasionally, they'll actually know the name of a claim or defense. Very rarely do they understand that the law defines what must be proven, right, to stand up those claims and defenses. And so we help them over the course of their litigation sort of construct or architect that house. Claims and defenses, elements, facts supporting those elements, and then, and only then, evidence to make sure everything all lines up. So that's one discipline that we want our users to develop. The second component is strategy. Again, litigation, real litigation, takes a long time, and there's a lot of procedure to do. Right? We want to make sure that folks understand where they are at any point in the case procedurally, like what is the procedural history, but from there to then evaluate options, reasonable options for what to do next, right? And so there's a strategy component that makes sure they understand the procedural history in layman's terms. They can understand any document that's been filed or served in the case in layman's terms. And then they can engage in a conversation with our strategy agent about what to do next and what those options mean. All right, we don't tell them what to do mostly, but they can make a good decision. They get some information on how to do that. The third component is our documents catalog. Pretty much anything you want to file in a real civil litigation is there, but it's not a typical document generator. It takes into account the rules that apply to that procedure, takes into account the fact pattern, the underlying fact pattern, the procedural history that is relevant to that procedure, takes into account the case law, valid case law that applies to that procedure, and then it generates a document based on the position that the user wants to take on that procedure. There's also for documents that require it, motions, responses, that sort of thing, there's oral argument simulation, so that folks aren't going in cold to court to argue that they've actually practiced it as much as they want on our platform. The fourth component, though, which I think is the most powerful, is our community. Think of it as a social network for not just pro se litigants, but pro se litigants who are using those other tools to practice law for themselves, right? Our goal, again, is to change the behavior of self-represented litigants so that they are doing this actual work that you all are familiar with, but that most self-represented litigants are not. The community, it lets them share. Right? When they win on a motion, they come and we call it ringing the bell. They come and share what worked, what didn't work. They show what they're doing in proof, strategy, documents, etc. And what we found over a few years of doing this is that these folks are overwhelmed. They're generally up against a lawyer who is intimidating them, beating them up in court. They can have some psychological consequences of that experience that shut down real work. And so we have a community that gives people emotional support and helps them do this very difficult work. I think that's probably the most powerful feature of it. We're on a pay-as-you-go model. Folks can enter the accelerator for $1. That gives them some exploratory credits to just play around and make sure this is going to work for them. And then they buy credits as they go throughout their litigation. Yeah, I think that's all I want to share there. The other important thing is that we don't take everybody at this point. I talked a lot about universal access. We don't have universal access yet for this product because a lot of people come to self-represented litigation not ready to do the work. They're looking for a form to download, something really easy. Can I just push a button, right? And we dissuade folks like that from doing it. The way we do it is to actually make them apply for a spot in the accelerator. And they do that by watching that's not going anywhere. I won't take our time. I want to get to my colleagues here. But essentially, they can watch a 15-minute webinar. They can read a 10-page white paper, get a quick email series that explains the realities of litigation and why this work is necessary. And what we found is that folks who are willing to do that are willing to do the more difficult work of litigation, right? And so we require that. They have to take a quiz showing they have absorbed that material. It's an easy quiz, but if they're willing to do the work, and we let them in for $1 and they go on from there. And so essentially, I'll stop there. But if you're interested, I'm happy to walk you through. Personally, it does take a good half an hour to show you all the wonderful features. But yeah, that's what we're doing. One other thing I did want to show you, if you're interested, at the bottom of our website there is a partners link. We are, as Jessica indicated, we want to work with folks as well. We have great relations with North Carolina Legal Aid. We're based in North Carolina. I just want to call out Cherie Gilchrist at the back there, who has worked with us in many ways and helping us connect with self-represented litigants. And there's some courts that do the same. But we are really open to a lot of partnerships. We want universal access to our courts for the benefit of all of us. So I'll stop there. Thanks very much.
Sonja, thanks so much. Our next speaker is Casey Chiappetta, who is Officer, Data, and Technical Assistance at the Pew Charitable Trust. Casey?
Hello, everyone. Hi. So like Bob said, my name is Casey Chiappetta. I'm a program officer at the Pew Charitable Trust on the Courts and Communities team. And what my project does is we work with courts. Better? Okay. My project works with courts across the country to keep unnecessary cases out of court, and then for cases that do have to go to court, to make sure that they get the right amount of attention. Pew is a nonpartisan think tank based in DC, and we work on evidence-based reforms to help government work better for folks. And today I'm going to talk with you all about a new project that I'm standing up, which is using large language models, LLMs, to unlock information in documents and turn that into structured data that can help courts make better decisions. So a little bit of background, one of our focus areas is consumer debt, and over the last 6 years, we've worked with 13 states across the country to get court data, analyze it, and work with advocates in the state to pass reforms. Debt collection impacts millions of Americans each year. In 2022, there were 4.7 million lawsuits filed, which can deepen financial distress and destabilize people's lives. And through this work, we really learned of a lot of problems in working with court data, and one of that being locked information in documents. So last year, we launched a cohort of 6 states to use data to inform decisions, not just around data and documents, but all things from collecting court user feedback for the first time in Washington State to launching new probate trial codes in Massachusetts. And that really showed us that there's even more data to unlock. So now we are doing it. So our new line of work, as both of those lines kind of wrap up, expand, we're exploring a partnership with Stanford Legal Design Lab to expand their legal help commons to work with state courts to integrate LLM-supported models to read documents, pull data, and do cool things with that. We're also partnering with a data science and AI professor to test the best ways to get this data from documents. And then we're currently piloting or starting to pilot work with 3 states to test, does this actually work? Do states want this? And how best can we scale it? So I'm going to talk about how we're thinking of combining these 3 lanes of work: debt, data, and technology, which is using LLMs to review underlying documentation of a debt collection lawsuit. One of the reforms that we like to talk about when we work with states is proof or documentation of debt. This means that when a case is filed or when applying for a default judgment, the plaintiff has to provide information so it's clear who's being sued, why they're being sued, and that the plaintiff is the right owner of that debt. And very importantly, the court needs to review this. And I just want to highlight before I talk about what that court review looks like, a couple of things that the Uniform Law Commission includes as this documentation. So for instance, there's information about the debt, like the last four numbers of the account, the date of charge off or default, and then if it's a third-party debt buyer, including information about like the chain of ownership, date of each acquisition, etc. But like I said, it's important that the court reviews, and these are a lot of cases. So like I said, 4.7 million lawsuits filed in 2022. This can be thousands of cases that a judge has to review every year. And past research from Minnesota and Connecticut, two states with some pretty solid documentation of debt requirements on the books, show that courts still enter judgments even when this documentation is not sufficient. There was a recent study by UC Berkeley looking at Connecticut, and they found that of 88 judgments where a judgment was entered, none of them fully met the statutory requirements for this documentation of debt. So when we talk with courts, we both talk about like what these reforms should include and also what this review should look like. And we've highlighted a couple of things. So things like using checklists to confirm that information is sufficient. Wisconsin does this, for instance. Empowering judges to dismiss cases that have insufficient documentation. And then the thing that I'm going to talk about today is using AI to review this documentation in bulk to kind of streamline review for judges so they can make decisions about what to do next. So on the screen here, I have a kind of high-level flowchart of what this can look like. Where this documentation is reviewed is really jurisdiction-specific. It can be reviewed, for instance, as I've outlined here, right after a case is filed. So after a plaintiff files a case with court, an LLM reads and queries the document, checks the documents against filing requirements, and then for the court staff produces a checklist of what's present, missing, or incomplete. So that way a judge, clerks, and other court staff can make a decision about whether to request that additional information, whether to dismiss the case. This is not replacing jobs. This is really giving court staff and judges the information they need to review these cases, which might not be reviewed in this level of detail already. And then something that I think is a good way to think about what this review looks like is you can tell a new employee to just go figure it out, or you can provide them really detailed instructions on what to check and how to check it. And that's what we're interested in doing, is that set of detailed instructions. So for instance, on the screen here, I've included a part of a decision tree that we've built to kind of help us think through what that review should look like, because there's different types of things to review if it's a credit card debt versus auto debt. So for instance, if it is credit card debt, does the plaintiff include a monthly statement or bill? And does that include the last four numbers of the account? And there's other things as well for other types of debt, like auto, payday, medical, etc. This takes a lot of work, but it's very kind of simple if you break it down into just enough steps. So we're really excited about this work. Like I said earlier, we're piloting or starting to pilot this work, not necessarily documentation of debt. There's a couple of other topics with some states. But in 2027, we plan to launch an RFP for 10 states to stand up a cohort that want to undertake similar projects, not just around documentation of debt, but really about like unlocking this information from documents, turning it into data, and then taking action on that. So I want to preview a little bit about what we're thinking, and I would love feedback, thoughts from you all. So the way that we're thinking about it is projects will have to be impact-oriented, necessary, and not a substitute for policy change. And what I mean by impact-oriented is they have to improve the way that people interact with the courts by reducing unnecessary interactions or lead to policy changes that, for instance, reduce disparities and negative impacts on court users like costs, time, things like that. And what I mean by be necessary is really kind of like the principle of least power. So AI is not the solution for everything. Like if you have a solid form, maybe just OCR, for instance. And then lastly, and I think really importantly, not be a substitute for policy change. So for instance, one example that I like to think of is like an expungement tool. What if expungement were instead automatic? And how can we support courts in moving in that direction? And then in exchange for participating in this cohort, projects will get resources and technical expertise from us. And like I said, we're exploring a partnership with Stanford's Legal Design Lab, process and policy reform and implementation insights. So for instance, with the documentation of debt checker, thinking about like how has the percentage of default judgments decreased? What are we looking at in terms of participation throughout the life cycle of a case? Expertise in stakeholder management. So for instance, if you're going to launch a documentation of debt checker, you need to tell plaintiff attorneys ahead of time. So that way they're not surprised when they're starting to get requests for more information. And so that way too, they can also make sure that when they're filing these documents, that all of that documentation is really there. And then lastly, projected impact and evaluation of what that can look like. So I know we have time for questions after this, but if you want, here's my email. I'd love your thoughts on what we're proposing to explore. And this ties in really well with my next panelist, who is from Stanford and doing this work with the LA County Courts.
All right, and last but not least is Daniel Bernal, the Associate Director of Research at the Rody Center for the Legal Profession at Stanford Law School.
All right, give me 1 second till I get ready here. Excellent. So my name is Daniel Bernal. I am the Associate Director of Research at the Rody Center on the Legal Profession at Stanford Law School. For the last 2 years, I've had the privilege of quarterbacking a project with the Los Angeles Superior Court System, the largest trial court in the country. We spent a first year doing a lot of diagnostic research to see what are some problems that we potentially can solve with the court system. Largely, we narrowed it down to a couple of key participation problems, so low participation, unjust resolution, and lack of transparency, but that has fed all sorts of challenges feed into that. So that was like step one. We figured out what some of the problems were, and we decided, let's create some solutions. So the last year, we've been focusing on 4 different interventions that we've started to pilot, including increasing participation of tenants in eviction cases. We have a randomized study about how to improve participation. We have ways to improve quality of resources for litigants through AI-powered referral system. Then we also have a tool called the default assistant, which is similar to what Casey was talking about in the debt collection context. And finally, building a new ODR system in both family law and civil cases with a partner project with ODR.com. So today I want to focus on just this one intervention, the default assistant, to build some synergies here, but I'm happy to talk more about any of these if people have questions. So the spotlight here is on the default assistant. And I just want to really quick mention I'm a part of a much larger team here, including a lot of technical expertise. The reason that I'm able to talk about this today is really Teddy Warledge, who's a PhD candidate at Stanford in the computer science department, and Othman, who's a data scientist, are the ones who built this tool that I'm going to be talking about. So in LA Superior Court, there is a crisis in debt collection filings, just like all across the country. Last year alone, 100,000 debt collection cases were filed in the court. That means that about 50% of those went through the default judgment process. So the court is processing 50,000 default judgments just for debt collection. And that is, I want you to imagine that you are the research attorney who is assigned to do that. And there is someone, I'll use a different name here, his name is Alex, who primarily is responsible for doing that. Tens of thousands of cases a year that come across this. And so here's the statute. The statute says the complaint shall allege X, Y, and Z. of it. And in California, there's actually some teeth to the statute. It says, in an action initiated by a debt buyer, no default or other judgment may be entered against a debtor unless business records authenticate all that stuff we just showed you before. So someone, Alex, has to go through all the documentation that's been filed, sometimes 100 pages or so, and verify this. As you can imagine, it can be pretty difficult, but here's just 7 things that we're looking for. So we want to make sure there's similarities between the requests that you're making in the complaint and actually in the judgment itself. You're looking for the original agreement, the existence of a declaration, etc. Courts, though, rely on manual methods of review. So that means combing through the pleadings themselves. Well, we'll go here. It means combing through the pleadings themselves. It means looking through the original. Credit card statements of bills of sales. It also means these great PDFs that we have that go vertically down the page, and you have to trace them to try to figure out, oh wait, when did this person last pay on page 50 of the PDF? So this results, as you might realize, in a significant error rate. So we had a bunch of students and myself go through a coding process. We did 200 cases. We found that 26% of the judgments entered in 2024 had major errors that should have prohibited entry of judgment. This is tens of millions of dollars in debt that went to be collected, could have resulted in wage garnishments and other negative financial impacts on the community in Los Angeles. 14% had errors that should have reduced the judgment amount. So they exceeded the local cap on attorney's fees, or they double counted something in the judgment. And so what we decided to do is we built a default assistant that would allow us to allow the research attorney to be able to have some support in reviewing the documentary requirements. So here are the 7 requirements in a sample case. This is something that we've tested, we're about to launch in the field. It looks at all those 7 requirements using an LLM, and it says, hey, where are the potential flags that we see here? So in this particular case, one of the questions that we're asking is saying, hey, based on the date of last payment that is actually substantiated in that huge body of evidence that you had to submit, is there a problem with the statute of limitations? Which is, as you all know, a very, very big issue that we can actually sanction the attorney for filing a case that is after the statute of limitations. And the tool allows you to understand the different sub-requirements of here. So first we want to know, is there an exhibit in the declaration that substantiates that date of last payment? And then it allows the research attorney to look at the source document. So you can go through and you can see here's where we pulled that information from. So what we did is we did a standalone evaluation of cases that went through the court system. The court denied 1 out of 14 of the cases that had these major errors, and our tool flagged 12 out of 14. I'm happy to go into some of these in specifics if people are interested. We also then wanted to test it in as close to real world conditions as possible before launching in the field. And so we had 66 law students that volunteered for an event we called Judgment Day. We trained them like the research attorneys as much as we could. And then we broke them out into different groups. Some of them got randomized to use the tool. Some of them did not have access to the tool. And we tried to see how accurate were they, how efficient were they, et cetera. And we found that they were much faster and they were more accurate. And so we were able to tweak the system a little bit with some differences we found, but overall we had some really promising results. So I think I'll leave it like this for my initial version. I just leave my name there. If anyone is interested in more of the specific technical requirements here, happy to talk more and also put you in touch with the people who are the true experts here. So with that, I will leave it.
All right, so we are scheduled to have another 15 minutes. David just told me we can go a little bit longer if we want to do that. I've got some questions for the panel, but I wanted to stop at this point. You've heard the four presenters, and I want to kind of throw it open quickly to see if any of you have questions that you want to bring up before we go into the discussion. Yeah.
I know that unauthorized practice of law.
We want to make sure you're talking to the mic for the folks online.
I know that unauthorized practice of law is a big thing in this field. How are each of you kind of facing that?
Well, it's a great question, and one we get at Courtroom 5 a lot from everybody but our customers, right? There's been a huge just evolution over, I think, the last decade. A number of states are experimenting with ways to reduce the threat of it. Colorado, most recently, the Attorney General's office published a non-prosecution policy around UPL. So if if an organization does X, Y, and Z, they won't be prosecuted, right? And that I think offers a great deal of clarity to companies like Courtroom 5. So we know, just what the standards are. One of the challenges in UPL is that nobody's actually defined the practice of law. So what is unauthorized practice of law, right? We haven't had a sense of where the lines are. And so the Colorado policy is very helpful. There is some work to sort of open source that for other states that are interested. So we're participating in that conversation. But frankly, I think, and I don't want to get myself in trouble here, but I think it's become increasingly difficult to enforce UPL these days, particularly with AI technologies. It's all of our colleagues have mentioned, pro se litigants are using ChatGPT and other technologies, and yet you're not going to find a state bar going after, OpenAI or Anthropic or anything like that. They would prefer, frankly, and apologies to any regulators in the room, to pick on, paralegals doing divorce paperwork and that sort of thing. And so I think it is increasingly difficult for them to regulate tech, right? And so some people have suggested we at Courtroom 5 give legal advice. We argue that we give legal information artfully delivered, right? But there are fuzzy lines there, right? But all of what we do is technology. And so we don't fear UPL as much as we used to, for instance. I would just call out one other thing. There's a U.S. Supreme Court opinion, I think a week or two ago, Childs v. Salazar, I think it's called. Some of you may know it's the case of conversion therapy. The state of Colorado tried to ban conversion therapy, and the U.S. Supreme Court decided they couldn't do that because it was a free speech issue, right? And I think that has some implications for things like UPL, right? So we, are just providing speech. We're just doing speech. And so it will be difficult, given that latest opinion, for a regulator to say, well, no, we're going to ban what you're doing, right? Because of that. So anyway, long story short, I'm not as concerned about UPL as we used to be.
I've hit the arc of my career now at 15 years where stuff I did in the beginning where with document assembly or expert systems, there was the argument of whether that was violating UPL. And now it's AI and it's more this advanced technology. I still point people back to Mark Lauritsen's First Amendment arguments, and I probably once a week send out links to his articles he's written about that. So the First Amendment argument, falling back on that. We also in the litigant portal have a guiding principles document that is on our GitHub repo if you want to check it out, but it falls back to the stuff I learned when I was watching Illinois Legal Aid Online do it. And they had what you should do versus what you could do. And being very specific in the information and the output from our system is that it falls on the you could do this, not you should do this, or similarly situated people have done X, Y, Z. You should, or you could also do that. And so our guiding principles document really is our way of putting all of this information and knowledge that legal aid and self-help tools have been doing for 30, 40 years into our AI side of it. So you can check out it on our GitHub repo.
Casey, Daniel?
I'm good on this one. Go ahead.
I mean, the only thing I would just add, point out something we all know, which is a couple of states, Arizona and Utah, have basically gotten rid of those prohibitions and allowed the creation of these things called, alternative business structures, and Washington now has done that as well. Stanford, the Rhodey Center did a study about a year ago or so of these programs, which found that overall they've been effective. I think in Utah has been a little bit more effective in really addressing A to J issues in their model. There was recently a series of newspaper articles that came out of Arizona that raised some questions about the safety of the Arizona model insofar as it's allowed this sort of cottage industry of law firms that are setting up shop in Arizona but then practicing all over the country. I think the verdict is still out on the implications of that. But there is a model for getting past the A to J restrictions that has proven to be successful. And I think also, just to Sonja's point, you hardly ever really see anybody enforcing A to J anymore. I mean, this used to be a thing when states would bring actions against LegalZoom or whatever, Rocket Lawyer, and that's just not happening anymore. So I don't know how much of a real concern it is, although I know it certainly weighs. I talk to a lot of startups who the one thing they want to know is, are we going to get in trouble with what we're planning? Usually I tell them I wouldn't worry about that. Focus on what you're doing.
And Bob, I guess I would note is from my perspective, the projects that we're working on, the issue is not UPL. It's about judicial neutrality and court. And so the question is, when we're building these tools, default system, for example, what can courts check for? What things can they do without the defendant coming and participating and raising an issue herself? And so I think a lot of times the courts are not under the same constraints of the UPL necessarily, but they're trying to figure out, how can we be responsible and what sort of posture do we need to adopt, recognizing the breakdown of the adversarial process.
That's a great question. Thank you for that. Any other? Yeah.
My question is specifically for courtroom 5, but anybody can feel free to answer. I love the idea of helping pro se litigants prepare for going into court and oral arguments. I think for me, though, the challenge that I have in weighing this is they're still not trained lawyers. They haven't been to law school. They haven't gone through the training necessary to go in there and be able to handle stuff. As you kind of pointed out, they're competing against somebody who is a trained lawyer, and then they're getting beaten up. And so I guess for me, what I'm wondering is there opportunity there instead of we're going to prepare you to go into court and still possibly get beaten up, or, hey, we're going to help you get 90% of the way there, but let's see if we can't connect you with a lawyer who's trained and kind of take over the other 10% at maybe a lower rate. Because I just still worry that even I'm going to be a law school graduate, and I can tell you, I'm sure the first time I go into court, even as a trained lawyer, I'm going to be terrified and probably get beaten up by a much more experienced lawyer.
We've experimented actually with models like the one you suggest, and the problem is the demand is there for pro se litigants. They'd love to work with a lawyer on a limited scope basis. It's very dangerous for lawyers to take on that work. That's the challenge. And so if you think about it from a lawyer's perspective, you take a retainer if you're doing full representation. Part of the reason is you've got to do a lot of study on this person's case, right? There are all kinds of peculiarities that might pop up, and you want to just be fully informed. That's part of what a retainer will let you do. With limited scope work, you don't get that. Right? You might charge $200 or $300 for a document review or something like that, but you're never going to get the full scope of this person's case. It's easy to make a mistake, right? And as soon as something goes bad, you're risking this person filing a bar complaint or a legal malpractice claim, and it's just really, really dangerous. And many of the folks who are even thinking about limited scope are solo practitioners or small firm folks. And, you've got malpractice insurance rates that go through the roof if there's a bar complaint. It's just really, really difficult to take on that kind of work as a solo or small firm practitioner. So the demand may be there from pro se litigants, but the supply is really, really difficult and risky.
Any other comments on that? I mean, I would just add that, economists who've studied this studied access to justice have demonstrated that there will just never be enough lawyers to meet the demand for all of the self-represented litigants in the world. So no matter how much some programs like Courtroom 5 try and connect self-represented litigants with lawyers, there just are never going to be enough lawyers to meet that demand. And at least, I mean, you talk about them going into court and getting beat up by a lawyer. At least Sonja's like giving them some protective gear and showing them how to throw a punch before they get in there. They're better off than going in, with absolutely no training whatsoever, I think. So, I think it's really important to have programs like that do equip litigants with at least some of the skills they need to go in and represent themselves.
Well, I think Daniel's statistics showed that real lawyers doing it are doing it wrong 12 out of 14 times. So like having that data, like I don't think we should throw self-represented litigants under the bus. They know in their heart what the story is and their life is on the line. So that makes you very committed to being as prepared as possible when they do programs like Sonja's talked about. And let's just assume most people are intelligent and can handle it. Like the whole argument that lawyers have this special magic that we can whip up in court, there's incompetent lawyers across the board too. So I don't think we should discredit self-represented litigants as much as possible with preparation.
The other thing I would add is just that I do think that there are situations in which a little learning is a dangerous thing. And so, one of the papers that I came out with was an RCT where we gave self-help information to tenants facing eviction in Arizona. And we actually found that it led to worse outcomes for tenants in certain situations. So tenants with large corporate landlords. There may be situations in which giving them access to a certain amount of tools, but that doesn't change a power imbalance, could potentially lead to worse outcomes, that you have a retaliatory action or something against you. And so I do think with all these, we should be engaging in rigorous evaluations of the effectiveness of the tools and potentially of the unintended consequences of everything, because there may be that certain interventions that we're trying do lead to outcomes that just aren't enough. It can help them only so much, but it's still going to result in them getting evicted or worse.
Just read some of the AI hallucination cases if you think lawyers are always the most competent representatives in court. Oh.
Yeah. So I have a question. Can you hear me?
Oh, sorry.
Oh, sorry.
Oh, sorry. No, you go.
Okay. Hi, my name is Cara, and I have a bit of a question and a challenge for the room. So the last meeting like this I was at was LSC ITC, which I'm sure a lot of you were at as well. And the vendor area, the vendors who showed up to, want to serve this community, we were all together and we were talking between sessions. And one of the gaps, or one of the things that we started talking about, was there seemed to be a pretty big gap between what we were building and what was being adopted. And this kind of doing things one at a time, each of us trying to talk to everyone one at a time. So these bespoke sort of solutions were causing unnecessary slowness. So we started having a conversation about how should we work together? Like, should we create tools that work together? Should we create a consortium that provides solutions? There's no good housekeeping seal of approval, right, for legal tech. So I would say maybe we could talk about that a little bit today as we're together. How can the users, the people who need these tools so desperately, work with the vendor side who's building really cool tools, but it's very hard for the community to tell the difference between the good ones and the bad ones, work together better to solve some of these problems so that we can move the needle. So a bit of a challenge, a bit of a question, but it goes exactly to what Bob was just saying. There's never going to be enough lawyers, so we need these tools. So how can we as a community kind of knit this together better to solve it as a community? Thanks.
That's a great point, Cara. Anyone who would comment on?
I'll just share. Hi, Cara. It's good to see you. I would just share, we we think of the work we do at Courtroom 5 as co-development with our users. We just, we put something out there. We know it's not perfect. We get a bunch of feedback. Oh, I did this. I used it this way. And we are, we watch them. So we survey them. We hear what they tell us, but we also watch what they do and how they use the tools. And we collect enough of that feedback and input to develop the next version. And that's sort of our product development process at Courtroom 5. And so we do, we're learning from our users. So my co-founder and I got into this business because we needed to learn how to litigate for ourselves, but we're not typical. And our users have really educated us on just how average people engage the court system. And that's been the basis for our product development. So I love that question. I appreciate that.
There's also, not exactly to her point, there's this Justice Technology Association. I think you're part of it.
And Kara is as well. Yeah.
And which are part of this group of basically for-profit mostly companies that are developing justice tech and that share ideas and share resources as well in terms of what Kara's talking about. Now it was over. Now you're next, I think.
Hi, thank you. I love how how these tools are being used to prepare people for court or not go to court. And I was just wondering, do you see them being used while they are in court and after they leave court? Like, for instance, if someone is a per se, or even feels that they have ineffective counsel, to be able to review the transcripts, like getting transcripts are a big thing, because I know it's like thousands of dollars to get a copy of your own transcript. So that's unaffordable. Like, so I don't know. I was just wondering if do you see a future where that's going to help? I guess, and also, do you think this will change I know there's not enough lawyers, but it sounds like also we have too many indictments and too many cases. So I'm wondering also, do you see this technology as changing the fabric of the justice system?
I would certainly hope so. Absolutely. That's sort of our goal and a question we want to answer with what we do at Courtroom 5. I think most of our users use our platform out of court, right? They prepare for their moment or day in court, but they're working weekends, evenings, just preparing for preparing their cases. We're focused on civil cases only. We don't do criminal, but I do know that there are there's some work in the criminal justice system, helping people navigate their own criminal justice system. But I don't know enough about that side of the aisle to speak on it much.
I think the appellate level has an even larger, more egregious pro se problem, because they don't know to even ask for transcripts at the point of the trial. And so some of the preparation that these tools can do can give the cheat codes to prepare them for when they have to do the next level. So knowing to request transcripts or what to do after. I was sitting in a court observing a pro se day, and the person won. Like, they did everything they needed to do to win some claim against their neighbor or something. And they said, "Great, Your Honor, how do I get my money?" And the judge was like, "Oh, I can't tell you that. That's legal advice." And I was like, "No, it's not." But like, it was a simple, like, how do you, okay, you won, you did all the things, but what's the next step? And so I see our tool being available to say, okay, you did it, great, you won. Here is how you garnish wages, or you get a lien, or whatever the next thing is to complete the process for people.
And to your second point about like reducing kind of like the demand to go to court, I see AI and other tools like that as like a way to keep junk out of court. Like, some lawsuits shouldn't be filed. Like, it's the wrong person. They're not the right owner. It's outside of the statute of limitations. Like, if you can catch that before someone's wages are garnished 25% or their bank account is wiped out, like, that's a huge win.
I think it's worth pointing out that there's been a lot of focus this morning with the programs on access to courts as access to justice, but access to justice, of course, is much broader than that. There are whole categories of people who have legal problems that aren't necessarily court problems or that they don't need to go to court to resolve. We haven't really gotten into that, but I think AI has just huge potential for helping to triage and resolve a lot of those kinds of legal problems, or at least help better understand what people's problems are, help them get to the right resources. I think some of the student presentations you saw this morning are helping with that. So that's we're really kind of focused on courts in this conversation, but that's really only a slice of the broader access to justice issue that we need to address.
So I'm really intrigued by the courtroom 5 stuff in general because, as we've all said, it's most people just struggle and then get slammed. So the question really is kind of twofold. One is when I work at legal aid, so I'm constantly talking to people about like, I can't help you, but let's refine your argument, let's write it out, let's figure it out. So are you using AI at all to help people basically give them a script so that they can articulate their claims in a way that a lawyer might, if they were a good lawyer, in terms of like a concise script to the judge or whoever's there. And then also kind of sorry to go off on another tangent, but who is you said people are that the case law is kind of verified and the elements are matched to their claims. So who's figuring that out? Are there lawyers in the back end that are figuring that out?
I'll take your second question first. No lawyers on the back end, no lawyers on our team at all. The elements are public data. The law, luckily, in the United States is public. And so, again, I've got a PhD librarian on my team who just collects that data. I should also mention we're registered as an online document provider in North Carolina, which requires us to have a lawyer review some of the content. And so we have used lawyers to just review it, but they're not on our team. The first part of your question, though, is there are dozens of AI agents working on the platform to do very simple, discrete things. And so we've sort of architected the entire litigation process using, again, tiny AI agents. And so in terms of helping a user understand what claims might be viable, right? That proof tool that I mentioned, the proof feature. Again, if a user just comes with their story, we can extract facts that they've described in a very simple syntax. But then, based on their jurisdiction, suggest to them some claims if they're a plaintiff or defenses if they're a defendant that might map or match those facts. So we'll just suggest, do you think you have this claim or do you have that? And they can decide, oh yeah, I want to explore this claim or defense. And maybe they don't have all of the facts there. We might suggest or ask them, hey, did this other thing happen to strengthen that claim or defense? And so in that way, yeah, we do help them identify viable claims and defenses. I think also to Casey's point earlier, there are a lot of junk filings. People don't know, right? Something happened to them. They want to just sue somebody. And so we take that very seriously, and we help people understand early on whether they have viable claims or defenses in their cases. So.
David, how are we doing? One more question?
Hi. Congratulations. This is all amazing. Listening to you all, I am reminded about a sort of famous study out of Jim Greiner-Schaap at Harvard about proving that a pro se litigant couldn't get a divorce in Philadelphia, right? Like that was impossible. And that we have other jurisdictions where easy peasy. So my question to you all is, how are you thinking about the amazing data that you're collecting, the evidence, the sort of structural analysis that you're doing that has gotten so sophisticated, how we can feed that into the pipeline for law reform, and how AI can actually help us, because and some of you are working with massive data sets, and AI could say, I mean, Daniel, I'm thinking, you're going through how do we do this easier? So I just, because at the end of the day, it's just a really broken system that we're turning ourselves into pretzels to make work. So how do we change the system is my question to you.
Yeah, I think that's a great question. So one of the things that we're thinking about is like, we don't want to stand up a tech cohort. We want to stand up like a people cohort where there's like real stakeholder engagement to see, like, based on what we're pulling from these documents, should there be changes to court rules, statutes, and then figuring out the right vehicle to make those changes. So like, for instance, let's say a documentation of debt reform just requires documentation for third-party debt buyers, and it doesn't apply to original creditors. How can we work with the court or the legislature to expand requirements to hospitals, to auto lenders, et cetera? And then I think that when we're thinking about what states we want to work with, I think there's one track where we can improve how the court process works, but there's another track of like, can we investigate some cool research questions to see if something needs to be changed? Like, for instance, are bail conditions, which is something that's in documents, are bail conditions related to the underlying charge? And if not, how is that impacting people's lives? And maybe there should be some changes and reforms around that.
I think data is really interesting for policy change that we, probably if you're in this room, you have the gut that says this isn't fair and it hasn't been fair for a very long time. And I've seen it in our defender work too and on the civil side. That doesn't sell it for some people if they're not going to buy into like, this is such a terrible situation that people's lives are on the line, and if that doesn't do it for them, using the data can be a business case then for process improvement in the court system, in efficiencies of how many people can you get through the system, or do you have a lesser of an error rate? Can the judge handle more cases? Do you get a better ROI? And so data can help us prove what we've all felt all along and we cared enough to work on, but to make the case to other people who might not have that same gut instinct.
All right, well,
Let me just say real quick. I think I really appreciate that question because AI does have the ability to supercharge data analysis, right? And so for us, like if we've got, I don't know, 1,000 cases in a particular county, in a particular legal matter, there are going to be some patterns that automatically surface, and we can help the next 1,000 users in that county, in that legal matter, do better based on those patterns.
And I would just know that there's always going to be some enterprising, whether it's companies or courts that are, kind of ahead of the curve. And so for like our court partnership, we think it's our responsibility to really collect really good data of how things are working, to package the tool in a way that it can be used in via court stack and other California courts or across the country. And so like we want to build the evidence base of what works and what doesn't. And having a partner that is willing to do that rigorously is really a huge blessing.
All right, great. All right, well, Sonja, Jessica, Casey, Daniel, thank you so much for your insights and contributions today, and all the great work you're doing.
I think we're just about ready in the back. Looks like they're doing the last little bits. So I'll stall for a second or two. How about that weather? I suppose my one request is that maybe you let Greg skip the line so he's done eating by the time. I imagine the line's going to snake for a while. Other than that, we're gonna have some lunch. We'll give you some time to eat, and then we'll have our keynote at the tail end, and then we'll move on to have a wonderful extra day. I don't know if I've done quite enough stalling, but you probably can go ahead and start a queue. I will tell people there are chairs up at front, and for the people online, it's packed in the back, and you can't tell because all these empty chairs up front. So please be welcoming in your tables to people so they can sit down and have a horizontal surface to eat on as opposed to in the chairs on the back. I guess we can start